Already, nearly half of the states have or will pass laws that will ban abortion, while others have enacted strict measures regulating the procedure. Those states highlighted in red here on this map. Those in yellow are led by Democrats, which have taken steps to protect abortion access.
Let's take a closer look at some of the legal ramifications of this ruling. Evan Bernick is a College of Law professor at NIU. He joined to discuss this further. Professor Bernick, thank you for being here. We appreciate it.
Thank you for inviting me. I wish it was under better circumstances.
Okay, so let's get your reaction to this ruling. What does exactly does this mean, at least in the short term here?
In the short term, it means that abortion is either banned or on its way to being banned in more than half of the country. There's never been a single Supreme Court decision that's resulted in so much activity that was once constitutionally protected becoming illegal. And that's because a number of states have already enacted laws prohibiting abortion that were set to be triggered in the event of Roe's overruling. And other states have pre-Roe laws already on the books. So that's how, despite the fact that the decision formally leaves the decision to the states, the fact of the matter is that most states have already made that decision in a particular way.
It was a very long ruling today, more than 200 pages. Many are expressing concerns, as I mentioned, the Governor Pritzker, Mayor Lightfoot, talking about that maybe other rights could be taken away, contraception, same-sex marriage, sexual intimacy between same-sex couples. Do you think those concerns are justified?
I think they are, despite the fact that the court says that it is not addressing any of those rights. It's just addressing the right to terminate a pregnancy, and that's the only right that, as of this decision, does not exist. And it's because the method that the court uses to determine that the right to terminate a pregnancy doesn't exist basically involves looking to determine whether in 1868, a wide number of the states recognized and affirmed that right. And if you look at what was happening in 1868 with respect to contraception, with respect to same-sex intimacy, to say nothing about same-sex marriage, you are not going to find a deeply rooted historical tradition affirming that right. So if the court is asked to revisit those decisions, asked because a state, say, for instance, tries to ban IUDs and put pressure on Griswold v. Connecticut, which is the decision holding that there's a right to use contraception, it's not clear that those precedents will last particularly long.
Interesting. Okay, so Professor Bernick, tell us what you foresee happening from here. Are there legal battles to come? Are folks going to push for example, President Biden to pack the court? What do you see foresee happening from here?
So the abortion wars preceded Roe, and they are going to succeed Dobbs. This isn't going away. And the conflicts are now going to take place first at the state level with respect to people traveling to other states in the hopes of securing abortions where Roe is in effect still the law. States that are anti-abortion have already taken steps to try to prohibit that activity, which raises constitutional concerns involving the right to travel. So that's one battle. The other battle involves Congress. Both sides of this fight are not going to stand pat after this decision and just say our work is done. There are already moves by Republicans in Congress to consider legislation and calls by conservative lawyers and law professors to propose legislation that would prohibit states from allowing abortion. And on the other side, there are efforts to codify Roe by pro-choice advocates. So that's where the battles are going to be in the years to come.
So we had a ruling today, but clearly a lot more ahead. Professor Evan Bernick, thank you for being here and helping us understand what's going on here.